And depending on what your matter is that is before the commissioner, say whether or not legal representation should be allowed. So if your matter is for misconduct, remember the one that we spoke about earlier, when we spoke about breaking of the rules?
Yes.
Or it's a matter of what we call incapacity. Incapacity can stand on two legs. You can either be medically incapacitated. I can't do the work that I'm supposed to do anymore. I'm not attending regularly, etc., etc. And then I need medical certificates and those kind of things to say that, look, Ronnie can't work any longer. He's really had enough. The sickness is really getting to him. The second one is what we call poor work performance. The company gives you certain targets to meet. And normally it applies very well when it comes to salespeople, or because they are the ones that need to meet certain targets with regard to their workplace. And so when they fail in those targets, the company is entitled to then bring them to the Ccma. So if your matter involves that, you are not automatically entitled to legal representation. Then there are others that will not apply directly to employees, which is Section 69, Section 73A, Section 198A. The ones that I've mentioned there is to deal with compliances by the companies with regard to the Labor Relations Act and Basic Conditions of Employment Act. Because normally what you would have done with regard to those, you would have taken them to the Labor Department to be able to deal with it. But the Ccma now has the capacity to be able to deal with that. And so under those circumstances, if your matter involves any of those, the commissioner together with the parties must agree for legal representation to be allowed. And the commissioner has got certain criteria that he follows in determining whether or not legal representation should be allowed. He looks at